Hi, everyone. Thanks for joining us. We're going to go ahead and get started. My name is Ben Cass, and I'm a partner in Husch Blackwell's Energy and Natural Resource Practice based out of the Denver, Colorado office. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast, but if a fuller answer is needed or we run out of time, we will answer later via email. A PDF of the presentation is available in the resources folder. This program has been approved for legal education hours, and to report your hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We will use your feedback to plan future programs that are applicable to your business needs. That is all for housekeeping items, so let's get started with our program. We are excited to be talking with you today about recent trends in engineering, procurement, and construction, our EPC contracts. And joining me today are attorneys Steve Neely and Diego Atencio. Steve is a partner in our Washington, D.C. office and part of our firm's Energy and Natural Resources Group. He focuses his litigation and arbitration practice on renewable energy, construction projects, and government contracts. And Diego is an associate in our Austin, Texas office, where he represents developers and financing parties in real estate and construction matters for solar, wind, and battery projects. So let's get started. As an overview, within our broader renewable energy practice group here at the firm, the three of us and a few other attorneys here head up our Specialized Project Contracts group. So we specialize in drafting, negotiating, and reviewing the technical project contracts that form the building blocks of renewable energy projects, including EPCs, PPAs, O&M agreements, supply contracts such as turbine supply agreements, module supply agreements, and battery supply agreements, and asset management agreements. We represent both owners and contractors, and so we feel we get a wide view of the market, and we see a significant amount of deal flow, so we try to use that to keep up with what are the latest trends in the market. So this map shows locations across the country where we have recently worked on these types of specialized contracts for wind, solar, and battery storage projects. Over the years, we've worked on approximately 15 plus gigawatts of projects across 47 states, and recently have seen lots of battery storage work in the Northeast and Texas, as well as in Hawaii, and solar and wind projects across Texas and many of the Midwestern states. This pie chart here represents, let's just say, non-scientific, non-peer-reviewed rough estimate of the breakdown of types of EPC contracts we've worked on this year by project type. This breakdown, I think, reflects the trends in the market right now, with bigger pushes into solar, both utility scale and distributed, as well as battery storage. And although wind has dropped off slightly, we are still seeing strong activity in the wind sector. So next, I'm going to discuss a few trends in specific EPC contract concepts, and the first of those being force majeure and weather impacts. So Diego will touch on force majeure generally later in the presentation, including COVID-related impacts. What I'm going to talk about now is specifically weather-related impacts. And one of the more commonly negotiated provisions in any EPC contract is the definition of force majeure as it relates to general weather impacts such as lightning, rain, snow, wind, and flooding. From an owner perspective, owners will want contractors to familiarize themselves with the geography, terrain, and historic weather patterns for the project site, and to use their expertise to plan a project schedule to minimize impacts of weather to the greatest extent possible. Owners are also usually trying to meet a tight project schedule and are generally hesitant to allow a contractor to have an excused delay for weather events that should have been anticipated during the time of year in the specific geographic region. From the contractor perspective, contractors are often caught between the need to meet the demands of a project schedule and avoid liquidated damages, while at the same time meeting the obligation to perform the work safely and in accordance with applicable laws. OSHA and other state-specific requirements may prohibit a contractor from working in conditions that are dangerous to human life, such as during lightning events or extreme temperatures, or in slippery conditions such as mud, ice, and snow. So even if a project is in, say, upstate New York in the winter, and snow and ice events are objectively likely, it may be tough for a contractor to mitigate weather impacts if the project schedule calls for working during these winter months. Further, working in muddy or flooded conditions may cause damage to the project site, which would have to be later corrected at contractor's expense. Also, equipment manufacturers have restrictions on installing certain equipment like turbine components and solar panels above a certain wind speed, or you risk voiding the warranty. So while some EPC contracts will have purposely vague language regarding weather impacts from force majeure to allow parties to work to resolve the issues in the field, we are seeing a trend of the owner and contractor attempting to reach a fair resolution in advance by defining a weather delay day and allocating a number of days for which each of owner or contractor bears the risk of such delay. So for instance, an EPC contractor may agree to take the risk of the first 5 weather delay days that occur without excused relief from the project schedule, but if the project suffers more than 5 weather delay days, the contractor will be able to obtain excused relief from the project schedule. So this concept is not new. It's been used for quite some time with wind EPCs, known as a wind delay day, and it's used where wind speeds are too high to safely lift turbine components. But what we are now seeing is this concept move into solar and battery space as well. Like force majeure, the division of risk and responsibility for site conditions and unforeseen site conditions is a commonly negotiated topic. From the owner perspective, contractor is expected to have a high level of expertise in working in a variety of site and soil conditions, and is expected to perform the work for a fixed price specified in the EPC contract. The owner obviously wants to avoid costly change orders once the project is underway. From the owner's perspective, then, contractors should bear a substantial amount of risk of varying conditions at the project site. From contractor's perspective, contractor believes this is owner's project, and owner should generally bear the risk of informing the contractor of the conditions at the site and should bear the risk of discovery of unforeseen conditions, such as the discovery of endangered species, historic artifacts, buried pipelines, or storage tanks. If a geotechnical report has been prepared in advance by the owner, contractor will expect to be able to rely on what is in the report and, more importantly, rely on what is not listed in the report. We are seeing a relatively recent trend of EPC contractor bearing responsibility, usually pursuant to an LNTP, of conducting its own site analysis and geotechnical report, and the results of that investigation serving as the dividing line between what is a foreseeable and an unforeseeable site condition, with the specifically identified conditions in the report serving as the foreseeable conditions, and anything not included or reasonably inferable from the report being treated as an unforeseen site condition. We are also, however, seeing contractors recently take on additional unforeseen site condition risk as it relates to varying soil conditions and the location and impact of buried bedrock features. Also, another hotly negotiated topic, the warranty obligations under the EPC contract are nearly always negotiated, and the terms and conditions have been shifting as of late. As to the warranty term, we are seeing the standard term of contractors' overall workmanship warranty increase slightly, especially in the distributed scale solar market. While warranty full wraps are still being used, meaning the contractor is taking on full responsibility for all warranty obligations, including for subcontractors and suppliers, especially in smaller projects. We are seeing many owners either procuring various equipment components of the project themselves or specifying equipment purchases by contractor, and in either case, the warranty is directly passed through from the supplier to the owner, but usually enforced by the contractor during the warranty period. In the battery storage context, full wrap warranties are relatively rare, and with each battery solution and use case being so dramatically different, we are seeing quite complex warranty structures as different hardware and software components are being provided by different manufacturers and all tied together by the general EPC contractor. We've had to craft some quite complex warranty structures in the battery storage EPC context this year, and recommend taking the time to think through all potentially overlapping coverages and issues. From the owner's perspective, the ideal scenario is to have one point of contact for all warranty issues during the warranty period to cut down on finger pointing between the contractor and subcontractors. This also helps the contractor manage expectations and coverage risk. On the topic of serial defects and recurring defects, we've seen a deeper dive this year into these issues and additional coverage provided from subcontractors and suppliers. We recommend considering whether this coverage extends beyond equipment defects to specific aspects of the workmanship warranty, including especially the installation of solar panels. Also consider whether if there's a serial defect in a widely used item like a solar panel, whether there's coverage for the additional labor involved in removing all the defective panels, packaging and shipping them off, and then receiving and installing the replacement panels. A few other quick notes. In the builder's risk insurance context, we've seen some changes this year in the insurance market with new sublimits for coverage on damage to the project from certain things like hail damage or micro-cracking of the solar panels due to on-site handling or faulty installation. So be sure to check your policy limits and ensure you've got your limitations of liability tied to these new sublimits. On the topic of payment and performance security, we are seeing proposals by owners to use bond products as payment security from owner to contractor in lieu of an LC or cash in escrow. And finally, on the topic of contractor financing, we are seeing some interesting requests from owners for contractors to self-finance parts of the project by delaying payment on work performed or setting payment milestones much further out in the future. This has been most typically used for LNTP work prior to construction financing being in place. And so with that, I will turn it over to Diego Atencio, who will be talking about force majeure and COVID-related impacts.
Yeah, thanks, Ben. Hi to everybody on the call. We appreciate you taking the time to join us today. My name is Diego Atencio. I'm an associate in Husch Blackwell's Austin office. As Ben mentioned in his introduction, my practice focuses on real estate and construction matters in renewable energy development and financing. So today I'm going to start off by discussing a few of the government orders that were imposed across the country in an effort to slow the spread of COVID. After that, I'm going to discuss certain important provisions in EPC agreements that are affected by the ongoing pandemic and how our clients are dealing with the risks presented by the pandemic as they negotiate their EPC agreements. So as many of you probably know, when the virus started spreading across the country, governments had to determine which in-person business activities were deemed essential, such that those activities would be allowed to carry on despite concerns about spreading the virus. The federal government didn't impose any restrictions of its own, but the DHS issued a non-binding memo that offered guidance to state and local governments about which industries should be deemed essential. For purposes of the presentation, I'll refer to that memo as the ECIW, which stands for Essential Critical Infrastructure Workforce. So once state governments took action, we saw that the restrictions that they imposed were pretty varied in terms of their restrictiveness. In New York, building new renewable energy projects wasn't prohibited outright, but construction activities were only allowed to continue if the project was necessary for the continued operation of certain critical infrastructure, like transit facilities and healthcare facilities. So while most renewable energy projects, could claim that they would contribute to the operation of critical infrastructure, it probably would have been either difficult or impossible for most developers to prove that their new project was necessary. This was the case with a project that was being developed by one of our clients who ultimately chose to pause construction until the restrictions were lifted. You can compare New York's approach to the approaches taken in Texas and Missouri, which were fairly relaxed in comparison. So in Texas, the governor's order relied on the ECIW to establish which activities were essential, which ultimately meant that nearly all energy-related activities were allowed to continue. That being said, the order specifically stated that all activities that could be performed remotely had to be performed remotely, even if they were deemed essential in the ECIW. And finally, in Missouri, the governor's order didn't require any businesses to cease operations. The government did impose certain social distancing requirements and limitations on in-person gatherings, and any activities permitted under the ECIW were exempted from those restrictions. So what we saw is that state governments didn't approach these restrictions in a uniform way. And depending on where your project was located, your project may have been shut down or possibly unaffected by the government orders. And if we're looking forward, it's difficult to predict how governments might react to further COVID outbreaks. We don't know how the virus is going to evolve as the year moves on. But there are a lot of experts who think that there could be a second wave of the virus this fall. So that could mean that governments across the country, could impose another round of restrictions. And in light of that possibility, anyone who's in the business of developing and building renewable energy projects, should pay careful attention to how those risks are addressed in their EPC agreements, which is what I'm going to be addressing in the next few slides. So I'm sure everybody on this call has dealt with force majeure provisions in the past and probably the recent past. But it's important to address how these provisions work and how parties are modifying these provisions to address COVID risk. As I'll discuss later in this presentation, and as Ben kind of referred to earlier, EPC agreements are now being drafted in a way that puts force majeure provisions in the back seat when it comes to addressing COVID delays, but that doesn't make them any less important to understand. So just to make sure we're all on the same page, a party seeking force majeure relief typically has to satisfy two elements. The first element is that an unforeseeable event has prevented or delayed the party's performance. And then the second element is that the adverse impacts of the unforeseeable event were beyond the reasonable control of the party seeking relief. So in other words, the party couldn't have reasonably prevented the negative impacts from affecting its performance. The second thing to take note of here is that force majeure provisions typically include a list of events that would qualify for force majeure relief, assuming that the two elements I just mentioned above are satisfied. These lists are drafted as either an open universe or a closed universe of events. In an open universe, the list of events is non-exclusive, meaning that a party could claim force majeure relief for events that don't appear in the list. And on the other hand, in a closed universe, a party could only claim force majeure relief for the events that do appear in the list. So, like I said, I'm sure many of you are familiar with how force majeure provisions work, but I thought it'd be helpful to address this on the front end for anybody who may not be familiar. Okay, so I mentioned in the last slide that force majeure provisions are taking a back seat in addressing COVID-related impacts, and so I'll explain why that's the case. At this stage in the pandemic, relying on the typical force majeure language to address the impacts of COVID isn't an ideal strategy for owners or contractors. From the contractor's perspective, it would be really difficult to argue that COVID-related impacts were unforeseeable, meaning that the contractor couldn't satisfy the first element of force majeure. Contractors also don't want to be denied force majeure relief if an owner believes that the delays could have been prevented by the contractor using reasonable means. Reasonableness is obviously a pretty ambiguous standard that usually requires a fact-intensive analysis. So what parties are doing instead is that they're starting to flesh out the specific mitigation actions that the contractor has to take if construction is impacted by COVID. From the owner's perspective, the contractor should have affirmative obligations to mitigate the impacts of things like COVID outbreaks and shortages in supplies and government restrictions on construction. For example, these obligations might require routine COVID testing for on-site workers, what to do if someone tests positive, how and when to reintroduce workers who have recovered from the virus, and what the contractor has to do while work is paused as a result of a government order. So these measures are usually set forth in the exhibits that address the scope of work or the safety plan. It might seem counterintuitive that a contractor would willingly accept additional obligations, but contractors have an interest in fleshing out these obligations, assuming that they're reasonable, for two reasons. The first reason is that the owner might be willing to agree to provide relief if the mitigation measures require additional time and expense, although owners will likely want to place caps on the relief that's available to the contractor. And secondly, once the mitigation obligations are fleshed out, they can be used to define the reasonable control standard under the second prong of the force majeure analysis if it becomes necessary for the contractor to rely on force majeure. So in other words, if the contractor performs all the required mitigation measures and still couldn't prevent further delays from happening, then the contractor would ideally be entitled to claim force majeure relief. So to wrap up this slide, what we're seeing is that EPC parties are agreeing to specific protocols for dealing with COVID-related delays, but force majeure is still available as a fallback mechanism for providing relief. Okay, so with that in mind, there are a few things to consider as you're reviewing and negotiating force majeure provisions in your EPC agreements. The first thing is that it's important to specifically reference COVID-19 as an event that qualifies for force majeure relief. That's true even if the list is an open universe. There shouldn't be any room for argument about whether COVID-related impacts are included in the scope of force majeure. The second point is closely related to the first one. While it's helpful to use broad terms like pandemic or epidemic, these terms may mean different things to different people. So it's important to specifically include COVID-19 in the scope of force majeure, even if the more ambiguous terms are also used. As to the third point, it's important to exempt COVID-related impacts from the foreseeability element of force majeure, since it would be really difficult for anyone to argue at this stage in the pandemic that they were blindsided by the impacts of the virus. Based on the agreements that we've worked on, this is a pretty common and uncontroversial modification to the force majeure provision. Another thing to note is that from the contractor's perspective, it's important not to agree to any language that would provide force majeure relief only in the event of a government order. As I mentioned in the first slide, the government may take a fairly relaxed approach to the virus, meaning that your work may not be prohibited under the government order, but you could still be dealing with an outbreak that impacts your performance, and you wouldn't be able to claim force majeure relief under your EPC agreement. And the last point here is for the benefit of owners. We recommend including a rep and warranty that the contractor has provided all known and material info about the possible impacts of COVID on the contractor's performance. The reason being that it's important for owners to stay apprised of possible risks to the project and get ahead of those issues to the extent possible. Okay, so I'll end my presentation by discussing a couple of high-level items to keep in mind. excuse me, owners should make sure that the performance deadlines and force majeure provisions in their offtake and financing agreements are consistent with the EPC agreements. For example, if the EPC agreement provides schedule relief to the contractor for delays associated with the contractor's specific mitigation obligations, owners should make sure that this doesn't make it difficult to meet the commercial operation deadline in their offtake agreement. Also, to the extent that the contractor claims force majeure relief under the EPC agreement, owners will want to make sure that they can turn around and claim force majeure relief under the offtake or financing agreement for the contractor's delays. On the other hand, contractors and owners who are contracting separately for equipment or materials should make sure that they're able to pass through any liability for unexcused delays to the third party responsible for the delays, to the extent that the owner or contractor wasn't able to claim relief under the agreement in question. Okay, so that wraps up my portion of the presentation. Thanks again to everybody on the call for tuning in. If you're dealing with any of these issues on your projects, please don't hesitate to reach out to our group. Okay, so I'll pass the mic to Steve Neely now.
Thanks, Diego. What I'm going to cover today is not so much necessarily new trends in EPC contracting, because these topics are things that are very common and have been around for a while, but rather a tendency that we've seen of perhaps overlooking certain contracting protections as being either formality or boilerplate. Specifically, I'm going to talk about issues relating to payment bonds, performance bonds, and liquidated damages. These are areas that, in our view, the parties are often treating these as checking the box to make sure that you have the bonds or you have the appropriate language with respect to liquidated damages, and you do that when negotiating and executing. But when a dispute arises later, if it does, you may find that these particular items do not necessarily provide as much protection as was originally hoped for or intended. So we'll begin with payment bonds. And just to clarify, there's a distinction between a payment bond and bonding off a lien. Some people may have different exposure levels to both types. When you bond off a lien, the bond is usually for a smaller amount, some multiple of the lien amount, for example, and it's not necessary to obtain the bond unless or until a lien is filed. A payment bond, in contrast, typically is obtained at the outset of the project, and it's for the purpose of guaranteeing a source of payment for subcontractors, laborers, and material men that work on the project. A payment bond typically is for a much larger amount, for example, the original contract price, and it can, in some states, prevent liens from being filed on the project. Probably the most common form of payment bond is the AIA 312. Its latest version is 2010. That form payment bond is often coupled with a performance bond for the project. In our experience, payment bonds are useful and provide benefits to both owners and contractors. The bond protects owners from being liable to unpaid subcontractors and suppliers for amounts that they're owed. It ensures that the contractor is also financially sound because they're going to be vetted by the surety in order to obtain the bond. And for the owner, it provides a third party who's going to be responsible for investigating and potentially resolving subcontractor claims so that the owner doesn't feel like it bears that burden if for some reason the contractor has been unable to take care of a subcontractor claim. This last part can be a significant benefit if the relationship between the owner and the contractor has soured or become somewhat contentious. The bond also benefits contractors because, again, it's a third party who's involved and will investigate if the owner is declaring a default. They'll also investigate subcontractor claims to determine whether or not they are properly payable. One of the benefits of a payment bond that is often overlooked, though, is that depending on the state where the project is located, there can be two types of payment bonds, a statutory payment bond and a common law payment bond. A common law payment bond is the most typical. It would typically apply everywhere, and it is the bond that just requires the surety to investigate and or pay subcontractor claims. But that's where the protections stop. it does not prevent subcontractors from filing liens on the project or suing to enforce those liens, even if they are also suing to enforce on the bond. A statutory payment bond, in contrast, does prevent enforcement of liens. This type of payment bond is the one that is most typical on public projects, because public projects are not subject to liens due to things like sovereign immunity. The federal and state statutes require that a payment bond be provided on public projects to ensure that subcontractors have a source of payment since they don't have lien rights. Some states, for example, Texas, Florida, Arizona, and Kansas, have extended this public project bond concept to private projects as well. The benefit of these statutes, particularly for an owner, is that if the payment bond complies with the statutory requirements, which includes typically recording it in the county records office where the project is located, but if it complies and is recorded, it can preclude enforcement of liens that any subcontractors or suppliers may file on the project. It does not necessarily prevent a lien from being recorded, just to make that clear, but it precludes enforcement of the lien and would render the lien largely a nullity. This can be a significant benefit for owners, particularly at closing, because if the owner and investors can rely on a statutory payment bond, it makes things like title insurance easier to obtain, and it may avoid the owner having to set aside cash reserves to set aside outstanding liens if and when they are resolved. But the trick to be aware of here is that there are very specific requirements that the bond must comply with in order to operate as a statutory payment bond. And in our experience, these requirements are often overlooked because the assumption is you're just going to use the AIA form payment bond that you use on projects across the country, or the assumption is if the bond is coming from a surety that is authorized to do business in the state where the project is located, you feel that the bond may automatically comply with the statutory payment bond requirements. In reality, that's not always the case. So for example, this slide provides the statutory requirements under the Texas Property Code for a payment bond to operate as a statutory bond. Among other things, the bond has to be in an amount equal to the original contract price. It has to have the owner's approval or endorsement on the bond. It has to be conditioned on prompt payment for labor, materials, and extras up to 15% of the contract price. And it has to have either information on how unpaid suppliers or subcontractors can make a claim on the bond, or it has to include the phone number for the Texas Department of Insurance. These are some of the more unusual requirements that I've summarized. There are some other very specific ones as well. So for example, the code requires that the bond be filed in the county records office, and it also requires that the bond include a memorandum or a copy of the applicable construction contract. And the recording requirement is obviously so that subcontractors and suppliers will have notice of that bond if they were to go and file the lien, for example. If these requirements are satisfied, the Texas Property Code provides explicitly that a subcontractor or supplier, quote, may not file suit against the owner or the owner's property. And the owner is relieved from any obligation to withhold money from the contractor to satisfy the outstanding liens. If you've worked on, for example, a Texas project, you know that you can frequently get what we would call a funds trapping notice, where a subcontractor says they have an unpaid amount and it is the owner's obligation to withhold. But if there's a payment bond, the owner does not need to withhold and will not face liability if it does not do so, at least under the statute. While these requirements are fairly straightforward, the parties may not pay very much attention to them in the contract and negotiation phase, and may not really think about them until liens are filed and investors or the title company start to raise concerns. The AIA form, for example, does not automatically comply with the Texas statute. It doesn't contemplate having the owner approve or endorse the bond, for example. There is a section to provide information about the owner, but it notes that it's for information only, and there's not a place for the owner to sign or otherwise indicate approval or endorsement. The AIA bond also does not include information on how to submit a claim to the specific surety that issued the bond, and because it's a form template, it doesn't have the Texas Department of Insurance phone number. And while it does have language regarding prompt payment of the contract balance, it's not necessarily specifically conditioned on prompt payment of labor, material, and extras up to 15% of the contract price. Now, to be clear, I'm not saying that the AIA bond will not serve as a statutory bond in Texas. It can. The Texas Code is very clear that it requires substantial compliance with the statutory requirements, not necessarily perfect compliance. And there are cases holding that a non-compliance with some of the requirements is not a substantial defect and does not preclude the bond from serving as a statutory payment bond. If the parties intend the bond to serve as a statutory bond, that is a relevant factor, and the AIA bond reflects this point. It specifically notes that when the bond is provided to comply with a statutory requirement, quote, the intent is that the bond shall be construed as a statutory bond and not as a common law bond. So that's very helpful language, but that alone may not be sufficient to prevail. So it's best to double check these requirements during the negotiation phase. Whereas some defects are not very substantial, if the bond is not in the original contract price, for example, that is much more likely to be found to be a substantial defect that will preclude the bond from serving as a statutory payment bond. One final point on statutory payment bonds is that, at least in Texas, the courts have held that it is really the owner's obligation to ensure that a bond complies with statutory requirements, because the owner is the party that benefits the most from the statutory bond effect, because the owner's property is precluded or protected from liens. So if an owner wants the protection of a statutory payment bond, they should require that bond from the contractor in the EPC contract, more so than just provide an AIA bond, for example, but perhaps an AIA bond that complies with the Texas Property Code or will serve as a statutory payment bond. And then when you get the bond, you want to double check to make sure that it is compliant, so that if your objective is statutory payment bond protection, you can be assured that you have that. Another area of overlooked protections is performance bonds. These are often used in lieu of a parent company guarantee as a means of ensuring that the project is completed if the contractor is terminated for default. In our experience, there are three main issues or areas of protection that we feel are often overlooked until a dispute arises or until the owner is actually considering invoking the performance bond and terminating a contractor for default. The first issue is whether the performance bond extends to warranty work. Typically, a performance bond will include language binding the surety to, quote, perform and complete the construction contract. The bond may include language requiring the surety to correct defective work and complete the contract, but it often does not mention warranty work per se. This can create some ambiguity because at the most fundamental level, a performance bond is intended to cover the initial construction and to ensure that the project is built. But once substantial completion occurs, the fundamental purpose of the bond is really satisfied. And it may not be readily apparent that the bond was intended to apply to warranty work, particularly not when the warranty work may not be required for more than a year later. We typically see warranty periods that are at least 2 years, which is a fairly long time for the performance bond to remain in effect. Ultimately, whether the bond will extend to warranty work will, of course, depend on the applicable state law for where the project is located. But the parties can certainly make this point clear in the bond itself. You can require language in the bond that it will extend to warranty work, or language in the bond that it will remain in effect during the warranty period. This can be a very significant benefit if there are defect issues that arise on the project that the parties are working through but have not necessarily resolved yet. If the bond extends to the warranty work, the parties may be able to agree to recognize substantial completion and deal with the defects under warranty. That helps the contractor because typically there's a payment component tied to substantial completion that the contractor obviously wants. It can also help the owner with respect to getting to closing. And so having that bond in effect can provide both parties some greater protection and allow the project to proceed forward. But if the bond's going to expire at substantial completion, it makes the need to correct the defects prior to substantial completion much more urgent. The second area of protection to consider with respect to a performance bond is whether the bond extends to liquidated damages. The AIA 312 bond is very good on this point. It specifically calls out liquidated damages and notes that the surety is liable for such damages, or if the contract doesn't specify liquidated damages, then the surety will be liable for actual damages caused by the contractor's delay. But other bond forms may not be as explicit as the AIA, so this is something for the parties to keep in mind during contract negotiation, and again, just double check as you're talking about that bond form or reviewing it. The third issue we frequently encounter with respect to performance bonds is that the protection they provide is not necessarily something that can be implemented quickly. It's not a quick fix solution, as anybody who's been through the process can probably attest. When issues or delays arise, the parties, the owner and the contractor obviously do their best to work through them. And that process often takes time. So you're having negotiation, you're asking when things are going to be completed, you're asking for recovery plans, et cetera. And the longer that goes on, the closer deadlines become. And when you start to run up against funding or closing deadlines, and as the dispute intensifies because it's taken longer, owners may have a desire to invoke the bond in hopes of bringing a new contractor in and just getting the project completed so you can move forward. But in practice, that's not as easy as it sounds. A contractor's defenses are not ignored when an owner terminates the contractor for default and invokes the performance bond. The surety steps into the contractor's shoes. They'll need to investigate the status of the project, and they can assert the same defenses as the contractor can. That's not necessarily a bad thing, but it can be difficult practically if the parties have avoided bringing the surety in. And that's common in our experience because the thought is that if you invoke the bond and bring the surety to the table, you're unnecessarily escalating the issues, which can be true, but at the same time, a proactive approach with the surety might also be beneficial because it helps the surety be involved, it provides a third party to help facilitate discussions, and it can facilitate completion of the project without getting to the point of a termination for default, which is in both the owner and the contractor, and for that matter, the surety's best interest. The last area of overlooked protections that we wanted to address is liquidated damages. And the caveat here is that liquidated damages themselves usually are not overlooked. They're included in most EPC or BOP contracts that we've reviewed for good reason. But what is often overlooked is the enforceability of the liquidated damages and whether or not the contractor has an ability to challenge the damages as a penalty. When an EPC contract contains the liquidated damages provision, the natural inclination, obviously from the owner's perspective, is to view the accrued LDs as concrete obligations. They're owed by the contractor. They should reduce the contract price and or should be withheld from progress payments if the contract will allow that. The contractor, in contrast, may disagree with the liquidated damages or believe that the amounts are unfair. And we find this to be particularly true where there's LDs that are tied to interim milestones. And with an interim milestone for LDs, if the project wouldn't be operational or revenue generating, even if the milestone was completed on time, that's an area where the contractor may feel that the LDs are particularly unfair or punitive. The complicating issue here is that some states may be more reluctant than others to enforce liquidated damages as written. Some state courts have historically viewed LDs as contrary to public policy and unenforceable because they're viewed as punitive. The more modern trend is to enforce liquidated damages provisions to the extent that the damages are a reasonable estimate of actual damages. This is primarily because the courts they're reluctant to enforce an LD provision that is punitive or that would really result in a windfall to one party. As a result of this reluctance, some state courts will consider challenges to a liquidated damages provision, particularly if the argument is that the liquidated damages are so excessive that they are essentially a windfall or a penalty. If that's the case, the court may find that the liquidated damages are unenforceable and that the only damages that are recoverable are actual damages. But that results in the parties having to provide evidence of what the actual damages are, which obviously they may not have contemplated doing, particularly since they agreed to liquidated damages. But the parties can mitigate the risk of those sorts of disputes and the enforceability of liquidated damages by ensuring, when you're negotiating the contract, that the liquidated damage amounts, whether it's per day past substantial completion or whether it's for interim milestones, make sure that those amounts are reflective or intended to cover actual anticipated damages, that there's some relationship or correlation between the damage one party expects and what the LDs would be. It would be more problematic if the liquidated damages are simply an incentive to keep the project on schedule, and so you pick a number that you believe is sufficiently high to create that incentive without being obscene. The parties might also include language in the EPC contract, particularly if you feel that these liquidated damages are a very reasonable reflection of actual damages. You can include a contractual waiver in your EPC contract where neither party is going to have the right to challenge liquidated damages as a penalty. That may not ultimately preclude a challenge later, but it does offer an additional argument for either party, particularly for the owner, to say that both parties understood the liquidated damages were reasonable and intended to reflect actual damages, and therefore any challenge of the liquidated damages as a penalty should not be entertained because the parties agreed to contractually waive that challenge. And with that, I'll turn it back over to Ben for questions.
Thanks, Steve, and thanks, Diego. Thank you to all of you for joining us today. We hope the information was helpful to you and to your organization. If you have any follow-up questions or comments, please do feel free to reach out to us by email. As a reminder, this program has been approved for legal education hours, and to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. So thank you all very much.